The Mischief Rule. Personally, I feel this is the best rule as it has a procedural sense and it has a set rule as to how to use it. This rule confers more discretion on a judge than the other two rules. The rule's definition comes from the case of Haydon, 1584, where it had been said there were 4 points that the court should address. These, in the old case's original language, were: 1. What was the common law before the making of the act? 2. What was the mischief and defect for which the common law did not provide? 3. What was the remedy the Parliament hath resolved and appointed to cure the disease of the commonwealth? 4. The true reason of the remedy. Then the office of all the judges is always to make such a structure as to overcome the mischief and facilitate the remedy according to this rule. The court should, therefore, look to see what the legislation was before the act was passed in order to identify what loophole or mischief the act was intended to address. The court should then interpret the act to cover the gap. This is clearly a method somewhat different from that of the literal rule. Cases using the Mischief Rule. In Smith v. Hughes, 1960, the Mischief Rule was used to interpret S1(1) of the Street Offences Act 1959, which specified that it is an offense for a common prostitute to loiter or solicit in a street or public place for prostitution purposes. The court considered 6 different women filing appeals against conviction under this section. The women had not been in the street in each case. One was on a balcony, and the other was on the windows of the rooms on the ground floor, with the doors either partially open or closed. In each case, by calling or knocking on the glass, the women attracted men's attention, but they pleaded that they were not guilty under this section because they were not actually in a street or public place. The court ruled guilty, with Lord Parker saying, "For my part, I tackle the issue by contemplating what the mischief to which this act is aiming is." Everybody knew this was an act to clean up the streets, enabling people to walk down the streets without being molested or approached by regular prostitutes. Viewed in this context, it can make little difference whether the prostitute is posing while on the street or standing in the hallway or on a balcony or at a window, or whether the window is closed or open or half open. There was a somewhat similar point in Eastbourne Borough Council v. Sterling, 2000, where a taxi driver was charged with plying for hire on any street without a license to do so. His taxi had been parked in the station forecourt on a taxi rank. He was found guilty as he was trying to get buyers off the street even though he was on private land. The judiciary responded to Smith v. Hughes and said it was the same point. If his car was placed so that the offer of services was targeted at people on the street, a driver would work steadily to hire in the street. Another case where the Mischief Rule has been used by the House of Lords was the Royal College of Nursing v. DHSS, 1981. In this situation, the language of the 1967 Abortion Act, which stipulated that pregnancy should be ended by a licensed medical practitioner, was in question. When the act was passed in 1967, the abortion procedure was such that it could only be performed by a doctor, a licensed medical practitioner. Improvements in medicinal practice from 1972 onwards indicated that the normal method of terminating a pregnancy was to stimulate premature labor by using drugs. A doctor administered the first part of the procedure, but the second part was done by nurses without a doctor involved. The court had to determine whether this proceeding under the Abortion Act was legal. The case went to the House of Lords, where the judges' majority, 3, found it to be legal, whereas the other 2 said it was not legal. The 3 majority judges based their decision on the Mischief Rule, attempting to point out that it was the unsatisfactory state of the law before 1967 and the number of illegal abortions that the Mischief Rule was trying to fix. They also said the rule's aim was to broaden the criteria for abortion and ensure they were done in the hospital with adequate skill. The other 2 judges ended up taking the literal view and said the words of the act were apparent and that abortions could only be accomplished by a registered doctor. They said the other judges did not interpret the act but rather redrafted with a vengeance. The Mischief Rule in detail. The Mischief Rule supports the aim of the law as it helps judges to look back at the loophole that the act was intended to protect. The focus is on ensuring that the gap in the legislation is filled in. This will most likely produce a just result. The Law Commission supported the Mischief Rule and proposed that it be the only rule used in statutory interpretation, as long ago as 1969. There are issues, however, with the mischief law being used. First, there is the possibility of judicial lawmaking. Judges try to fill the loopholes with their own ideas on how the law can resolve the discrepancy. Furthermore, the case of the Royal College of Nursing v. DHSS demonstrates that the use of the mischief rule is not always agreed by the courts. The use of the mischief rule might result in legal uncertainty. It is impossible to determine when the law will be used by judges or what will occur. That makes it hard for attorneys to warn clients about the law. Lastly, the mischief rule is not as broad as the purpose of solution, see section 7.9, as it is restricted to looking back on the old law gap. It cannot be used to take a more general look at the intention of the law. The three rules clearly will lead to different conclusions about the meaning of the words and phrases. The opposite is an activity based on a real situation where the different rules would lead to different decisions. Not even the literal rule keeps words in total isolation. It is common sense to look at the other words in the act to see if they impact the disputed word or sentence. Rules of language. Not even the literal rule keeps words in total isolation. It is common sense to look at the other words in the act to see if they impact the disputed word or sentence. Looking at the other words in the statute, the courts have developed a lot of minor rules that can help to clarify the meaning of words and phrases where a different form of the sentence was used. Such rules, which have Latin names as well, are the adjustum generis rule. The express mention of one thing excludes others. A word is known by the company it keeps. Case, Fisher v. Bell, 1960, 1 QB 394. The Restriction of Offensive Weapons Act 1959 S1, 1. Any person who manufactures, sells or hires or offers for sale or lends or gives to any other person, any knife that has a blade that automatically opens by hand pressure applied to a button, spring or other device in or attached to a knife handle, sometimes known as a flick knife, shall be guilty of an offense. Facts: the accused was a shopkeeper who had displayed the knife's handle. He was charged under S1, 1, and it was up to the court to decide if he was guilty of offering the knife for sale. There is a specific legal definition of offers for sale, under which it is not an offer to sell an item in a shop window. Students of contract law should know this rule. Get complete notes in PDF and book form from our Amazon store. Link given in description.